Three psychologists and behavioral scientists, Toshin Olonishakin, Adedeji Ogunleye, and Suleiman, I can't remember his surname now, sometime in February 2017, came up with some perspectives within the criminal justice system in Nigeria. They picked a few holes, and they started by saying this: the lack of credibility on the part of the criminal justice system in Nigeria, call it the implementers or the enforcers, talking about the police, the lawyers, judges, the Nigeria Prison Service, Immigration, Customs, the Economic and Financial Crimes Commission, ICPC, name it. That in the administration of this justice system and the law, they are responsible for an avalanche of social injustice, lack of discipline, and lawlessness in Nigeria and Nigerians. They went on to say that the supposed custodian of the law is largely indicted for being responsible for the ineffectiveness of the system in criminal behavior control. On the whole, the criminal justice system is an essential part of any civilized nation to ensure justice, fairness, the practice of the rule of law, and institutionalization of a democratic system. If there is a transparency in the criminal justice system, what happens and how can it be done? That will be the focus of this segment on Insight today. How can we achieve transparency in the criminal justice system in the Federal Republic of Nigeria? My guests, to my far right, I have Eric Ifere. Eric Ifere is member National Prosecution Coordination Committee in the Federal Republic of Nigeria, solicitor of the Supreme Court of England and Wales, solicitor and advocate of the Supreme Court of Nigeria, managing partner, Clearly Legal and Partners, consultant solicitor, Dominion Solicitors, England. Thanks for joining me on Insight.
It's nice being here.
Also, to sustain this discussion with me, I have Pius Oniga, Esquire. Pius Oniga is an Abuja legal-based practitioner with Kanu Agabi and Associates. Thanks for joining me on Insight.
Thank you for having me.
Beautiful. Just hitting the nail on the head. I'm aware that the criminal justice system in Nigeria has been kind of reviewed, and we now have the Criminal Justice Act 2015. Will you say it has been able to take care of all of what I've raised at the opening?
Yes, I will to a larger extent say that it's a very rich legislation, the Criminal Justice Act 2015. It did create a law that took care of the management of institutionalized bodies that took care of criminal justice system in Nigeria. It's quite encompassing, it's quite rich. It's got all of those things. Particularly, it removes some of, it's a measure of the Criminal Procedure Act and the CPC. And it went further to make sure that there is enough room for the enforcement of criminal justice system in Nigeria, and also to defend the rights of victims, the rights of defendants. Remember, within the provisions of the criminal justice system, suspects who are arraigned before courts are no more addressed as accused persons. They are addressed as mere defendants until perhaps they are convicted. So this law, enabling law, takes care of all these situations, and it went even further to reform some of the matters that were quite unacceptable, that abuse the human rights of persons. Take, for instance, within the provisions of Section 7 of that rule, you know, before now, anyone could be arrested in lieu of, perhaps, if they come to your house to arrest you and you're not there, your wife could be taken away by the police. The criminal justice system abolished it.
The current one?
Yes. It abolished it. It went further to say, before now, women were not even allowed to stand in for bail for people. It discriminated against the female folks, the women. But under this, it says no one should be. Women could stand in bail. But most importantly, I tell you, the most important innovation in this law is that created within section 4691 of the criminal justice system. It formed an enabling body with the established administration of criminal justice monitoring committee.
Okay.
That committee is made up of 9 members.
Okay.
And they were supposed to ensure that there was justice in all criminal cases. They were also to ensure the decongested courts. They were also to ensure that prisons were decongested by not detaining people who are awaiting trial unnecessarily. And this is a very beautiful innovation. So on the whole, I will tell you that the Criminal Act itself is a beautiful law, okay, which is a common thing in Nigeria. We are very good at transplanting. I mean, we could just bring in a law and then put in everything that we see happening somewhere. That's what they did.
Okay, let me get to Oniga now. You have, within the justice system, some structures around police, prisons, customs, immigration, EFCC, like I talked. Now, with the new act now, if they are not properly mainstreamed to tie with the new act, will it work?
Anyway, I want to start by saying that the administration of criminal justice system has 3 main components. Of course, the first one is the law enforcement. We move into the court system, and of course, sentencing. You know, without proper investigation, without thorough investigation, if matters are brought to court hastily, you achieve nothing. You know, the Administration of Criminal Justice Act 2015 has resolved quite a number of things. You know, like my colleague mentioned, prominent among them too is the provision of section 396 of that act, which clearly stipulates that there's need for day-to-day trial, and that is to ensure quick and of course speedy dispensation of justice. Before now, you know, matters could, you know, pend in court for 2 years, 3 years, 4 years, and the likes, and even beyond,
years.
even 20 years. Yes, you can't say that. You know, but today judges have the right, except for situations where it is impracticable for day-to-day trial to go on.
Okay, you talked about the issue of ensuring proper investigation, and now if within the current dispensation now, talking about the new act now, investigations are not properly carried out by maybe the police, customs, and they bring them to the court system, will it not bring some kind of disconnect?
You see, in most cases today that have come before even the Federal High Court, you see defendant counsel coming up with mere no case submission, and these matters are disposed with. They are disposed of.
Okay.
Not because the prosecution has finished doing the needful. Of course, it behooves on the police and other agencies of the federal government to conduct proper investigation before these matters are brought before the court.
Okay.
It is not in the place of the prosecution to compel the court to rule the other way around,
Okay.
where there are no facts and laws before the court.
Okay.
So where there is proper investigation by the police, and of course the prosecution is competent, all you need to do is you put the facts and the law before the judge, and judgment will naturally be in your favor, even though we have recourse to the fact that the prosecution ought not to become a prosecutor. But when the prosecution is able to do the needful, justice will be achieved.
By my little knowledge, I believe, and I believe it's knowledge of most other persons, that legal matters are things of utmost importance. But do we have within the act maybe a solicitor, an attorney, who attempts to truncate the process by way of trying to play games, what they say technicality? What happens within the act? For instance, Oniga is your lawyer in a case, and in an attempt to give you space to maybe to do a few things, it attempts to truncate it. Is it covered in the act?
Yes, it is covered in the act, you know. I'll give you a scenario. The Administration of Justice Act makes provisions for adjournments. It specifically says that you cannot have more than 5 adjournments in any trial.
369.
Like Oniga did say rightly, you have within 14 days, even if there were, the cases should be heard day to day, but not more than 14 days apart. Cases should be heard. The provision that is made here is for cost implications on lawyers who, for any reasons, are trying, like to borrow your words, truncate the trial itself. They are to be, the court at its discretion can award cost. This is akin to what is obtainable in England. But I think the main difference here would be here, the judge might award a cost against the litigant as a whole. But in England, there are 2 different kinds of cost implications. We have a cost implication against the litigants, who will be the parties themselves who are involved in this case. Then we have what they call wasted cost. When I spoke to some members of the MBA, I had some discussions with them. I did call for, in fact, when we were looking at this law itself, I did call for the introduction of what they call wasted cost. In wasted cost, it's cost awarded against the lawyer himself. So the court could look at it and say, listen, Mr. A, you've been playing games. You've been wasting too much time. Like we know, justice delayed is justice denied. And you'll be awarded some heavy cost. That would be a lesson to any of the lawyers. I think that has been captured in the Administration of Justice Act. There's cost implications.
Okay. Now, let's move on. Recently, the NJC, talking about the National Judicial Council, right?
Yes.
Directed heads of various courts to administer cases relating to corruption and other financial crimes. What's the implication of this?
Yeah.
Will it in any way ventilate and bring some measure, modicum of transparency within the criminal justice system?
Yes, I'd like to commend the current Chief Justice of Nigeria. He is proactive and innovative. You know, he has been able to set up a 15-man committee, the Justice Salamis Committee. That committee is aimed at ensuring the monitoring of all corruption cases that are pending in court. And of course, we are aware that because of his zero tolerance for corruption, he has equally instructed judges to ensure that there's fairness in the way they carry out their activities, that there's need for special courts that will handle corruption-related cases. Okay. I see that as a wonderful development, a step in the right direction.
Okay.
The reason is this, because of course, we know that, of course, the government of Nigeria today, government of the day today, has zero tolerance for corruption, and that most of the cases we have in our courts today are corruption-related cases. These courts are occupied with other matters, the regular matters we see in court, and that is able to forestall, that is able to truncate the activities of this prosecution.
Okay.
So by the time we have special court for this purpose, I see speedy dispensation of justice. Some of these people who are supposed to be witnesses in these matters, by the time you delay, some of them die. And what happens if your key witness dies? Your matter is spoiled. So there is need for this court, for this special purpose of prosecution to be in place. Of course, that is not to be that it will not have other side effect. We understand that judges today in Nigeria, the number of judges we have today is limited, except there will be more judges. Otherwise, if we pick from the number of judges we have today to make up the special courts, then other regular matters will suffer. Because today, you go to court, you discover that the judges are so occupied. And that is why it's difficult at times. They give you date for ruling, you go there, you can't even have that ruling that day. Okay. Not because they are not working, but because they are so occupied with so many matters. Okay. So if there will be need for this special court, then the corresponding need for more judges should be in place.
Okay, moving on now.
Yeah, but sorry, let me just make an observation, you know, a very short one on what you just talked about, special courts. I don't really buy that idea of specialized courts for criminal cases, for corruption. Rather, what I will go for will be specialized courts for specialized areas of law. We could have courts that will hear only criminal cases. If you're talking about administration of criminal justice, you're not just talking about corruption alone. You're talking about a fellow with a lot of other criminal cases. I think the problem is not about specialized courts for corruption, but rather, if you have to go for specialized courts, they should be courts for criminal cases, so that the judges over time, they can learn their ropes, having practice in criminal law, rather than today they are handling civil cases, tomorrow they are handling family law, and the next day they are handling employment. It doesn't do well for them. So we should have specialized criminal courts that will take care of all criminal cases. Okay. But I think the biggest problem, which he just said, was you need to employ or engage more judges. You also need to provide an enabling environment for courts to dispense justice. If you go to our courts and see how practice is done, I mean, it leaves you with so much doubt as to whether justice could be obtained. There are just too many cases that come in that shouldn't take the day or time of the court. Most matters could be dealt with on paper. Preliminary applications, a lot of other criminal bail applications, other matters, you know, for instance, adjournments, perhaps asking for leave to appeal, all could be dealt with on paper. And the presiding judge or the judge himself can sit in his chambers and decide in the first instance whether he grants that application or not, rather than coming into court and wasting time for lawyers to announce themselves when these matters will not even go on. It takes too much time. Then, if you look at the criminal justice system, it does recommend electronic recording of court proceedings.
Not longhand.
No. Longhand could still, judges still do the longhand as they could, but there should be verbatim reporting of what happens. So a judge could go back, litigants could go back and know exactly what you said or didn't say. I mean, we've reached, that is recommended there. But is it happening? No. They have to do that. So that transcripts, you can apply for transcripts of the proceedings of court, and you will have verbatim transcripts of what transpired, every word you said, and what your opponent said, okay, and what the judge said.
Okay, that's a good point there. But there's an opinion in the public domain now.
Yes. The
composition of the committee by the CGN, that what if now of the 15 members, maybe somebody sends in a petition to say Judge A, B, C, D is culpable, his fingers and his hands are not clean. What happens? What would be your opinion?
Well, in my opinion, it's not enough. We live in a society where people are very fond of bringing out spurious allegations about people without unfounded allegations. If anybody so decides to write a petition against anyone, I think the right thing will be that the other party be heard and a decision be taken. It's not enough to just write a petition. But if it is based on proving allegations on facts that anyone was corrupt and all of that, the law is very clear that such persons should not sit in such committees. But I wouldn't want to rely on speculative allegations against people.
Okay.
It's a very common thing in Nigeria.
Okay. Now,
sorry,
okay,
I was going to say something on that. You see, with due respect to the CJN, the composition of that committee is worthy of my note. The thing is this: I understand that almost all the past president of NBA are members of this committee, but we understand that these persons among the first 11 from the bar today in Nigeria. They handle high-profile cases. Of course, most of them corruption-related. How will it look like if these same persons have to say complimentary remarks or otherwise about judges tomorrow that their matters are pending before? Hence the need for the CJN, with due respect to him, to revisit that committee even before inauguration. Technocrats in the legal industry can be brought in. There are senior advocates who are in the academia. They should be brought in to be members of this committee. Not necessarily people who are still active. You can't expect an active player to equally act as a referee at the same time.
Okay.
Let the watchdog not become the dog to be watched.
Okay. Beautiful. Let me link it from there. And let me start with this analogy, because somebody raised it somewhere. He said, multiple criminal justice entities have remained resolute in their belief that the public need not oversee them. I'll come back to you. Somebody somewhere said the composition. How visible will it be to the public if we say transparency to be attained? And from this analogy, multiple criminal justice entities have remained resolute in their belief that the public need not oversee them. Now, somebody somewhere said some groups, like the media, Nigerian Union of Journalists, who have been brought in for visibility. Now, if this committee has been set up and they work at closed door, where lies transparency?
Well, talking about transparency, I don't really like dwelling on individuals' capabilities without, you know, having proven evidence to show that these persons are incapable of performing whatever they've been given to do. You know, if people have things against these people, I want them to come forward and put these things before the public domain, that these persons are not fit and proper to serve. You know, they are not fit for purpose. Put that out before the people and let the people look at it. Otherwise, I'm not given to basing my judgment and, you know, conclusions on spurious allegations. You know, people...
But what if the allegations are investigated and it is true?
Yes, then the law says, what does the law say? Such person should not serve. Let's not put the cart before the horse. Go ahead. If people have, let them come forward. We have the institutions that can take care of all.
You know, the committee has been announced.
Yes.
But, you know, the public is curious. Nigerians are agitated. Nigerians are concerned. Nigerians
never,
are anxious. Oh, the time has come. From what I read,
yes,
you know, these entities before, they were like, places you don't go near. You don't talk to them. You don't. They are like infallible. You don't go near. And this over time created this monster called corruption in the judiciary. And now the Chief Justice of Nigeria feel, let us demystify, let us break it. If they compose and they start work and the activities are not visible in the public domain, that's the concern.
The activities are not visible in what sense?
As in, okay, they are functioning. People should know.
Yeah, so what you're saying is that...
If there's no media component within what they are doing, will it work? Will the public know?
I see. You know, let's get this thing right. What you're calling for, in essence, is that there should be an open investigations of these matters. Is that what you're saying?
Beautiful.
Oh, yes, that's fine. I do agree with you. You know,
a situation where maybe they're in session and here is a closed-door session. The media is not allowed in to
yes,
let the public know what's happening. That's the concern. I'm not saying that the media should be made a member of the... We are not lawyers. It's strictly a legal, professional thing. But there should be some visibility given to what they are doing, because, like you said, before now, a woman could not bail somebody, and a couple of other things.
Let me just quickly point out something here that is quite commonplace in Nigeria. A lot of people are taken to the media courts, and they are adjudged guilty even before they are. It's been a very bad precedent that has been set in Nigeria. For instance, someone is arrested or suspected to have committed an offense. the proof of evidence does not establish that offense, the Nigerian media will throw you out to the dogs, condemn you, jail you, convict you.
No, they always say suspect.
Well, the way the stories are usually carried, I tell you something, some of the banners, some of the headlines are frightening. They are quite frightening.
Okay.
We have to be very, very careful. Sensationalism in reporting of criminal cases in Nigeria knows no bounds.
Okay. Let me move to Niger now. When will we in Nigeria attain the status where court proceedings are in the public glare? For instance, in Nigeria, it's almost like a misnomer to be in court and cameras are filming. Whereas in other climes, we watch proceedings. High-profile cases, judges are seen making statements, and you see what transpired. Why is it so? When will we have that in Nigeria? It's part of the problem.
Yes. You see, the topic in discourse is transparency.
That is it.
And that there can't be transparency without accountability. Let people be accountable for their actions and inactions. Of course, we see today the NJC has been able to punish quite a number of judges. But the other side of the coin that has not been addressed is the lawyers who corrupt these judges. It is very rare to see judges dealing with litigants themselves. These people are midwifed by the lawyers. Hence the need for the NBA to collaborate with the NJC.
But I thought they have always collaborated.
They have, but their collaboration, for me, with due respect, is not enough yet. You see, today, the Legal Practitioners Disciplinary Committee sits here in Abuja to address corruption-related cases and, of course, issues that borders on the professional conduct of lawyers across the country. They sit here in Abuja. Looking at the number of lawyers we have today, it is not enough. Hence the need for restructuring at that level.
Okay.
There is need for decentralization of the Legal Practitioners Disciplinary Committee. Say at least one per geopolitical zone where the people are closer to the lawyers back home there, so that you don't allow all the lawyers who have been alleged to have misconducted themselves in their professional regard to all proceed to Abuja to be attended to by the same committee. So this committee is not enough to address these issues.
So we say you're talking about devolution now.
Devolution,
Okay.
devolution, yes.
Okay. Back to Eric.
Sorry,
Okay.
yes. And then lawyers who are involved should be dealt with so that it will serve as a deterrent to other lawyers. Let not only the judges be punished. That is my submission.
Okay. They said all of us, we are within an environment, that is society, and that environment mirrors us. Is it possible that if the Criminal Justice Act as amended, 2015 Act, quite novel, very potent, it may not work if the society it operates in are impervious to change? Is it possible?
Well, I do not think there's any society that cannot change.
I use the word impervious.
Yes.
Yeah.
There's the saying that every law, there's no law that is greater than its means of enforcement. And the means of enforcement of every law is what the people will allow. I think the Nigerian society is beginning to change. I could see a lot of changes from such ostentatious living that we used to see around, that people flaunting wealth and all of that, to a more modest way of living. This is an innovative introduction. The administration of justice itself is not just about the courts. We must realize that. It's about the law enforcement agencies, all the institutions that are involved in this, the prisons, the prosecutors, the litigants themselves, the witnesses, the victims. I think we have to keep drumming it in the ears of members of the public that things have to change. And I sincerely believe that we are not deaf. Nigerians are not deaf. When Nigerians leave this society and they go to very civilized societies, you will not believe it how Nigerians behave. They change automatically. If they need to queue, they queue up. If they need to say please for everything, they say please. But when they come back here, they wear back the toga of the Nigerian way of doing things, in quote. Let us talk to ourselves. Let us change. I am sure if we change, we have good laws. The implementation and the execution is what the people will allow. Let us allow this law to work. You, me, him, everybody. The policeman doing the investigation, the law enforcement agents doing the investigation, the judges, the lawyers, the litigants themselves, the witnesses. Let us all do our bit. And we will have justice and fairness in this country.
Okay. Social ethnic factors here. When there was a slam on the judiciary in terms of anti-corruption, on the surface of it, good riddance. But maybe Eric was arrested, and because Eric is from the same clan where I come from, I condemned it. But because Eric is not from your own clan, you praise it. How can we come out of that? Linking from the points he just made. Because that remains a problem. Because Oniga is my tribesman. Whatever he does bad, I won't support it. I won't go against it. I will say what he's doing is correct. When can we come out of that mindset?
You see, like so many people will say, that the problem of Nigeria today, mostly, is ethnicity. Not even religion. Ethnicity first. Religion is secondary. Most persons tend to support that person from their place, irrespective of whether he's right or wrong. There is need for an attitudinal change. Let the people know that what is right in the East is right anywhere in the world. And what is wrong anywhere should be condemnable and condemned by everybody, not minding whether you have some level of ancestral lineage or connection with that person. So if we're able to address this issue and we begin to address the fact and the issues the way they are, not minding your political background, not minding your place of origin, not minding your state, your local government, then we will have a stable nation, have a sustained, legal atmosphere, and then we'll be able to protect the sanctity of even the judiciary, and there won't be need for self-help. You see, when a nation's judiciary is not in place, the people resort to even self-help because they believe that the best place that would have been able to resolve that conflict, when the conflict gets there, they will not see any result. Okay. If a man is certain that if you kill his brother today, justice will catch up with you, he will allow it. He won't even come after you to kill you in person. Because certainly when you get there, the trap will get you up there. Okay. It's only delaying. But if a man is certain that the court is bad, and that if you kill my brother today, the only way I can come after you is to kill you, because if I allow you today, you are gone forever. I would prefer to kill you. That is what is obtainable today. So there is need for us to revive the judiciary. There is need for us to do the needful so that the people can rekindle their hope in the judiciary. Okay. And of course the court system in Nigeria. Okay.
Back to Eric. I was enthused by your profile. You have practiced largely in England, Nigeria, and you're back in Nigeria. Comparatively, do you think we'll surely get there given where the clan you practice from?
Well, I think Nigerians are very intelligent people and hardworking. I have no doubt whatsoever that we will get there. I did practice in Nigeria for about 12 or so years before going to England, where I have practiced for more than that same period. I have compared comparatively both systems are completely different. Different in the sense that there are a lot of innovative ideas that we have here. We borrow from outside, but the problem we have is execution and commitment and the willpower to do these things. For instance, we took the idea of the sun, which is, well, I wouldn't say equivalent, but something akin to what they have there, the QC. But the way it's done here is completely different from how it's done out there.
But that's not why we're here today. Basically, is what word do you have for Nigerians towards attaining, achieving a transparent criminal justice system holistically, compared to where you're coming from, in a few words? Because this whole thing is about the implementers, the enforcers, the people themselves.
Yes, the public.
So in capping up, what will you say to Nigerians?
Yes, what I would say to Nigeria is, this is a beautiful country, and without justice, we are like in a zoo. We must make it work. The judges must make it work. The lawyers must make it work. The litigants must make it work. The members of the public, and then the government must provide an enabling environment for it to work. It's something that everybody must make his own contribution.
Okay.
That's what I think.
Okay.
With that commitment and the willpower, I think we will certainly get there. I have no doubt whatsoever.
Okay.
Yes, I like to say that most importantly is the need for government to address the welfare of judges. You see, if a man is hungry, the tendency that he will do what ordinarily he never imagined to do in life is there. If a man is sure that as he's leaving the court today, he's going back home to sleep well, to eat well, and of course has the necessary facilities and amenities around him, it will be difficult for you to bribe such a man. But where the man is hungry, the man's tendency to accept bribe will be higher. Our judges work very hard, tirelessly. Most of them don't sleep at all. While the lawyers return home, they retire back immediately into the chambers. So there is need for the government to address their welfare. Welfare is paramount. Welfare is ultimate. Though we know that few among them may be intrinsically and incurably bad in their nature. There are people who are like that. Irrespective of whatever you give to them, irrespective of whatever you do to them, they are bad, unrepentant. But this number cannot outweigh the number of judges who are good and who will work well, who will not be corrupted, who will not allow themselves to be corrupted if they are treated nicely, if they have a good welfare package.
Okay. Well, so that we don't get to a situation where maybe the interpreter of the law misinterprets the law. So that they will say the lawmaker becoming the lawbreaker. Well, I've been talking with Eric Ifere. Eric Ifere, like I said, is a member of the National Prosecution Coordination Committee in the Federal Republic of Nigeria, Solicitor of the Supreme Court of England and Wales, Solicitor and Advocate of the Supreme Court of Nigeria, Managing Partner, Clearly Legal and Partners, Consultant Solicitor, Dominion Solicitors, England. It was nice talking with you on Insight.
Nice being here with you.
We hope and believe by the next time when you come, we'll be talking about the gains of the new Criminal Justice Act in Nigeria.
We hope so.
And also we sustain this conversation with Pius Oniga, Esquire, legal practitioner based in Abuja with Kanu Agabi and Associates. It was nice talking with you.
Pleasure having me.